All right, so this got started pretty quickly, but the definition of trust was given, which I'll read another time, and that there's a fiduciary duty owed by the trustee to the beneficiaries.
Other terms for the settlor include truster, grantor, and donor. 1.4 Trust property required. A trust must have trust property, that is, the settlor must supply property so the trustee has property over which to exercise duties. Other terms for trust property include the principal, corpus, trust estate, and res. 1.5 Basic functioning of trusts. The settlor creates a trust by transferring legal title to the trustee, for example, a person with good investment skills, and equitable title to a beneficiary, a person or charity deserving of a windfall. The trustee manages and invests the property in accordance with legal duties and the settlor's instructions as contained in the trust instrument. The trustee makes payments to or for the benefit of the beneficiary following the settlor's instructions in the trust instrument. When the trustee's duties are completed, the trust terminates and the trustee distributes any remaining property to the remainder beneficiaries. 1.6 Purposes and uses of trusts. 1.6.1 Providing for and protecting trust beneficiaries. If the settlor does not want to give the beneficiary the property outright, the settlor can protect the beneficiary by creating a trust. Examples: beneficiaries may include minors, incompetents, those without management skills, and spendthrifts. 1.6.2 Flexibility of asset distribution. If the assets are in a trust, a settlor can provide for any type of distribution plan they desire, within legal bounds such as spreading benefits over time, giving the trustee discretion as to whom and how much to pay, and setting standards for distribution such as only for health, education, maintenance, or support. 1.6.3 Protection against settlor's incompetence. If the settlor is incompetent, a trust may be a better option than an expensive and embarrassing guardianship. Note: another estate planning technique which may be effective in avoiding guardianship is a durable power of attorney in which the property owner, principal, names a person, agent, to manage the owner's property with the authority either 1. Beginning immediately, or 2. Springing into effect upon the owner's incapacity. 1.6.4 Professional management of property. A trustee can be chosen for its ability to provide professional management of trust property. Examples: a bank trust department, trust company, or financial planner can be a trustee. 1.6.5 Probate avoidance. Property in an inter vivos trust passes outside of the probate process, that is, not under the settlor's will or, if INTE state, not to the settlor's heirs. 1.6.6 Tax benefits. Income, gift, and estate tax savings are possible. 1.7 Basic classification of trusts. 1.7.1 Express trusts. Express trusts are created by the express intention of the settlor. They fall into two categories distinguished primarily by the identity of their beneficiaries. Private beneficiaries, ascertainable persons. Charitable beneficiaries, indefinite class of persons or the public in general. 1.7.2 Trusts created by operation of law. A. Resulting trusts. Resulting trusts arise from the presumed intention of the owner of the property. B. Constructive trusts. Constructive trusts are an equitable remedy used to prevent unjust enrichment. 2. Trust validity. The first step in any trust question is to ascertain whether the trust is valid. There are 5 main elements of a valid trust: intent, identifiable corpus, ascertainable beneficiaries, proper purpose, mechanics and formalities. 2.1 Intent. The settlor's intention to create a trust is essential to the existence of an express trust. The settlor must intend to split the legal and equitable title and to impose enforceable duties on the holder of the legal title. 2.1.1 No formal words required. Intent may be manifested by written or spoken words or by the conduct of the settlor unless the statute of wills or the statute of frauds applies. No formal words are required. The settlor does not even have to call the arrangement a trust. An oral trust of personal property might be valid in some states. 2.1.2 Communication to beneficiary not required. Communication of intent to the beneficiaries is not necessary. Delivery of the property to the trustee is sufficient unless the settlor is also the trustee, in which case the settlor must segregate trust assets or otherwise show trust intent. 2.1.3 Must be manifested while settlor owns property and prior to conveyance. An intention to create a present trust must have been externally manifested by the settlor at the time they owned property and prior to its conveyance to another. However, the conduct of the parties subsequent to the conveyance may be evidence of an earlier intent. 2.1.4 Must intend trust to take effect immediately. The settlor's intent must be that the trust take effect immediately, not at some future time, although a future interest can be trust property. A promise to create a trust in the future, like a promise to make any future gift, is not enforceable unless the promise is a binding contract, that is, supported by consideration. Example: Father tells son, "You are a good son. Tomorrow, I will put $10,000 in trust for you." Tomorrow comes and father says, "Son, I'm going go on vacation with the money instead." Son cannot enforce father's promise. 2.1.5 Cannot change character of completed gift. Once an outright transfer of property occurs, it is too late for the alleged settlor to go back and claim the transfer was really one in trust. 2.1.6 Precatory expressions. A settlor's expression of a hope, wish, or mere suggestion that the property be used in a certain way is called precatory language. The usual inference is that precatory expressions do not create a trust because the settlor must impose a legal obligation on the transferee, not merely a moral one. This inference can be overcome by definite and precise directions. Directions addressed to a fiduciary, for example, executor. Under a will. A resulting unnatural disposition of property, for example. Close relative will otherwise take nothing, if no trust imposed, or extrinsic evidence showing that the settlor previously supported the intended beneficiary. Example: Testator includes the following provision in his will: I leave $50,000 to my son with the hope he uses the property for his children's education. Instead, the son spends it on a vacation. The grandchildren will not be able to sue successfully their father for breach of trust as no trust was created. 2.1.7 Split of title. Any split of title is sufficient so long as the sole trustee is not the sole beneficiary. If the sole trustee and sole beneficiary are the same individual, the equitable and legal titles merge and the trust terminates. Hypo 2a. Settlor. Trustee. Beneficiary. Permissible. Sam. Teresa. Bruce. Sam. Teresa. Teresa. Sam. Teresa and Bruce. Bruce. Sam. Teresa. Teresa and Bruce. Sam. Teresa and Bruce. Teresa and Bruce. Example: Susan creates a trust retaining a life interest for herself, the power to change the beneficiaries, and the power to revoke the trust. Susan is also the trustee and the beneficiary during her life. Upon Susan's death, Ellen is the beneficiary. A valid trust is created. Even though Ellen's interest is weak, subject to defeasance at any time. 2.2 Identifiable corpus. Because a trust is a type of property transfer, trust property is required. The property must be ascertainable with certainty. 2.2.1 No residential, no trust. Where there is no trust property, the trust fails because the trustee has no property to manage. 2.2.2 Sufficient trust property. The trust property must be an existing interest in existing property. A future interest may be held in trust, but an interest not yet in legal existence, that is, a mere expectancy, such as the right to inherit from a person who is still alive, cannot be held in trust. Future profits from an existing contract can be a trust res. The trust residential must be existing property that the settlor has the power to convey, including intangibles, for example, promissory notes, in which the settlor has an assignable interest. Examples: real or personal property, tangible or intangible property, vested or contingent interests, and contract rights such as the right to be a beneficiary of a life insurance policy. 2.2.3 Insufficient trust property. Property the settlor cannot transfer or does not yet own cannot be trust property. An unenforceable gratuitous promise cannot be the subject of a trust. Examples: the property of another person, expected future income or profits not supported by a valid contract, and an expectancy to inherit, or take under a will, from a person who is still alive. 2.2.4 Trust residential must be segregated from other property. The residential must be identifiable and segregated, but the residential may be a fractional or undivided interest in specific property. 2.2.5 Debtor cannot hold own debt in trust. A debtor cannot hold their own debt in trust, but the debtor can declare themselves trustee of particular property from which the debt is to be paid, and the debt can be held in trust by another person. 2.3 Beneficiaries. A trust cannot exist without someone to enforce it. Thus, an ascertainable beneficiary is necessary to the validity of every trust except charitable and honorary trusts. 2.3.1 Capacity. Any person or entity capable of taking and holding title to property can be a beneficiary of a private trust. The beneficiary need not be competent. 2.3.2 Incidental and indirect beneficiaries. Not everyone who benefits from a trust is considered to be a beneficiary. The trust must operate directly to benefit the person. For example, an attorney designated by the trust instrument is not a beneficiary. 2.3.3 Notice to and acceptance by beneficiary. Notice to a beneficiary is not essential to the validity of a trust. Lack of such notice may indicate, however, that no trust was intended. Acceptance by the beneficiary is required, but can take place after a valid trust is created. Acceptance may be express or implied and is generally presumed. 2.3.4 Disclaimer. No one can be compelled to accept an interest in a trust against their will. A beneficiary may disclaim an interest by filing a written instrument with the trustee, or, if a trust created by will is involved, with the probate court. If a valid disclaimer is made, the trust is read as though the disclaimant was deceased as of the relevant date. A time for making disclaimer. Many state disclaimer statutes require that a disclaimer be made within 9 months of the interest's creation, and that is the relevant period for federal gift tax purposes. The federal tax time limit does not apply to a beneficiary who is under age 21. A disclaimer is timely if made within 9 months after the beneficiary attains age 21. Some states do not impose a time limit. The beneficiary may disclaim as long as the beneficiary is not estopped from doing so. B. Estoppel. A beneficiary may be estopped from making a disclaimer if they have exercised any dominion or control over the interest or accepted any benefits under the trust. See disclaimant's creditors. Under most state disclaimer statutes, a disclaimer relates back to the date of the transfer for all purposes. In these states, a disclaimer by an insolvent beneficiary can be used to defeat creditors' claims but not a federal tax lien. 2.3.5 Anti-lapse statutes. The anti-lapse statutes in most states apply only to wills and come into play only if a will beneficiary within a certain degree of relationship predeceases the testator. See Wills Outline. Several states and the UPC apply the anti-lapse statute to future interests created in trusts, even to future interests expressly made contingent on survival unless the trust makes an alternate gift in case of a beneficiary's non-survival. 2.3.6 Divorce. A final decree of divorce or annulment revokes all beneficial gifts and fiduciary appointments in favor of a former spouse. The UPC and several states have extended the divorce revokes rule to beneficiary designations of individuals who are related to the ex-spouse but not the settlor. The governing instrument is read as though the former spouse, and their relatives, is deceased. 2.3.7 Definiteness of beneficiaries under private trust. There must be definite beneficiaries to have a private trust, not required in charitable trusts. Certain beneficiaries. Beneficiaries may be definite even though not yet ascertained. For example, unborn children. Beneficiaries must be ascertainable by the time their interests are to come into enjoyment. B-class gifts. Beneficiaries may be designated by generic descriptions such as children. Beneficiaries may be unascertainable when the trust is created as long as they are ascertainable when they are to benefit. For example, to my children and upon their death, to my then surviving grandchildren. The trustee must be able to determine who belongs to the class. Hypo 2b. Are the following descriptions of beneficiaries sufficiently ascertainable to be a valid class gift? 1. Grandchildren. 2. Siblings. 3. Friends. 4. The individuals who pass the next bar exam. See reasonably definite class required. If a private trust exists for the benefit of a class, the class must be reasonably definite. As long as the class is reasonably definite, the trust may authorize the trustee to exercise their discretion in selecting members to be benefited, or may provide that only those who meet certain requirements will benefit. Broad power to choose beneficiaries, however, may constitute a gift or a power of appointment rather than a trust. 2.3.8 Resulting trust remedy. Property reverts to settlor. If a trust fails for lack of a beneficiary, for example, because the beneficiaries are not ascertainable, a resulting trust in favor of the settlor or their successors is presumed. 2.3.9 Charitable trusts. Charitable trusts are for the benefit of the community in general rather than specified individuals. February 3, 10 Honorary trusts. An honorary trust is a trust set up to provide benefits for a non-human, non-charitable purpose. Examples: care for a pet animal, maintain a grandfather clock. Trusts for the care of pets are authorized in all states. Trusts for purposes not against public policy are authorized in many states. 2.4 Trust purpose. The general rule is that a settlor may create a trust for any purpose. However, a trust purpose is invalid if it is illegal. Example: to encourage the commission of crimes. Its performance requires a criminal or tort-ious act. It is otherwise contrary to public policy. It violates the rule against perpetuities. 2.4.1 Acts contrary to public policy. Public policy is violated if the purpose of a trust is to induce others to engage in criminal or tort-ious acts, encourage immorality, or induce a person to neglect parental, familial, or civic duties. If a condition attached to an interest is against public policy. The settlor's alternative desire controls if expressed. If the illegal condition is a condition subsequent, the condition is invalidated but the trust is valid. If the illegal condition is a condition precedent, the preferred view is to hold the interest valid unless there is evidence that the settlor's wish would be to void the beneficiary's interest altogether if the condition is unenforceable. 2.4.2 Rule against perpetuities. Under the common law rule against perpetuities, a non-vested property interest is invalid unless it is certain to vest or fail no later than 21 years after the death of a person who is alive when it is created. However, many states have adopted a wait-and-see approach or an alternative 90-year vesting period that would save the interest. A growing number of states have abolished the rule against perpetuities as it applies to trusts, permitting the creation of dynasty trusts. 2.5 Trustee. Once established, a trust will not fail because the trustee dies, refuses to accept appointment, or resigns. The court will appoint a successor trustee unless it is clear that the settlor intended the trust to continue only so long as a particular trustee served. The absence of a trustee may cause an attempted inter vivos trust to fail for lack of delivery. 2.5.1 Trustee must have duties. A passive trust, where trustee has no duties, is void, and the beneficiaries take legal title. In many jurisdictions, the duty to convey title to the beneficiaries is enough to make the trust active. 2.5.2 Qualifications of trustee. Anyone who has capacity to acquire and hold property for their own benefit and has capacity to administer that property may be a trustee. Minors and insane persons can hold property, but cannot administer. State statutes limit the right of some persons or corporations to serve as trustee, for example, foreign corporations. 2.5.3 Removal of trustee. A court can remove a trustee or refuse to confirm an appointment. Grounds for removal include serious breach of trust, habitual drunkenness, conflict of interest, etc. The basic factor considered is whether continuation in office would be detrimental to the trust. If the settlor knew of the grounds for removal at the time they created the trust, the court may choose not to remove the trustee. A beneficiaries must have grounds to remove. Absent grounds, beneficiaries cannot remove the trustee unless the power is specifically granted to them by the trust instrument. 2.5.4 Disclaimer or resignation by trustee. Before acceptance, a trustee can disclaim or refuse appointment for any or no reason. However, a trustee cannot accept a trust in part and disclaim it in part. A relation back of acceptance. A testamentary trust is treated as in existence as of the settlor's death, and the trustee's acceptance relates back to that date. It is thus possible for a trustee, by accepting, to become liable, in their fiduciary capacity, on tort claims arising prior to the time the trustee accepted. B. Resignation. Once an appointment has been accepted, the trustee cannot resign without court permission, unless all beneficiaries consent or the trust provides otherwise. 2.5.5 Merger of title where sole trustee is also sole beneficiary. If the sole trustee and sole beneficiary are the same individual and hold precisely the same interests, titles merge and the trust terminates. 2.6 Mechanics and formalities. A trust can be created by inter vivos transfer, by inter vivos declaration of trust, or by will, testamentary trust. 2.6.1 Inter vivos trusts. Inter vivos trusts are created while the settlor is alive either by the settlor declaring themselves trustee for another or by the transfer of property to another as trustee. The present intent required must be manifested by conduct, delivery, or words, declaring oneself trustee. Delivery means placing the trust property out of the settlor's control, unless the settlor serves as trustee. If a present trust is not established because there is no trust res, the trust arises when the settlor subsequently acquires the residential and remanifests trust intent. CMR chart to determine whether a valid private trust has been created. Look for the following characteristics: intent to create a trust, manifested by settlor's words, writing, or conduct, trustee trust property, res, definite beneficiary, IES. Note, same person cannot be sole trustee and sole beneficiary. Valid trust purpose, one that is not illegal, tortious, or against public policy, and does not violate the rule against perpetuities, elements of valid private trust. A present declaration of trust settlor is trustee. A trust can be created by a person declaring themselves trustee of specific property for a beneficiary. The settlor keeps legal title. B. Transfer or conveyance in trust settlor is not trustee. The settlor creates the trust by transferring legal title of property to a trustee. The settlor may retain or transfer the equitable title, but the settlor conveys legal title. C. Transfer, delivery, of property to trustee. See Declaration of Trust. If a trust was created by a declaration of trust, no conveyance of personal property is needed as long as the property is identified and segregated. Real property should be conveyed from the settlor as an individual to the settlor as a trustee. QLTS prep by BARBRI. Trusts. Notes. Enter any notes you'd like to remember here. 15. C. Conveyance in trust. If the trust was created by a conveyance in trust, the settlor must convey the property to the trustee. Real property is conveyed by deed. Personal property is conveyed by physical delivery or an appropriate written assignment. Delivery means placing the trust property out of the settlor's control. CMR exam tip. Failure to name a trustee, or a promise to name a trustee in the future, may evidence a lack of present intent and prevent delivery of the res. D. Formal requirements statute of frauds. C. Writing required for trusts of land. Most states do not require a writing for a trust of personal property. For a trust of land, however, a written instrument signed by the person entitled to impress the trust upon the property is commonly required under the statute of frauds. C. Part performance precludes statute of frauds defense. If the holder of the legal title acts as if they are a trustee, part performance will preclude the statute of frauds defense. The statute of frauds is to protect the donee of a gift from false claims that the donee is really a trustee. See parole evidence rule. Most states allow extrinsic evidence where an ambiguity appears on the face of the writing. 2.6.2 Pour over gift from will to trust. Under the Uniform Testamentary Additions to Trusts Act, a settlor can make gifts by will to a trust, even an amendable and revocable trust established during their lifetime. The trust must be clearly identified from language in the will. A. Governance of property. Property goes into the trust as the trust exists at the date of the testator's death, not how the trust was written at the date when the will was executed. Thus, trust amendments made after the will execution are effective to govern the poured over property. If the trust is revoked, the gift fails, lapses. B. Pour over property can be initial trust funding. The trust may remain unfunded during the settlor's lifetime. The pour over property can be the initial trust funding if the trust is identified in the will, and the trust is executed before the testator's death. 2.6.3 Testamentary trusts. Testamentary trusts are created in the settlor's valid will. A. Formalities. Trust intent and the essential terms of the trust, trust res, beneficiaries, and trust purpose, must be ascertained from the will itself, from a writing incorporated by reference into the will, or from the exercise of a power of appointment created by the will. B. Secret and semi-secret trusts. C. Secret trust. Constructive trust imposed. In the case of a secret trust, the settlor agrees with the will beneficiary that the beneficiary will hold the property in trust for someone else and relies on the beneficiary's promise, but the will does not state the trust nature of the gift. The intended trust beneficiary may present extrinsic evidence of the will beneficiary's promise to hold the property in trust. If the promise can be proven by clear and convincing evidence, a constructive trust will be imposed on the property in favor of the intended trust beneficiary. CMR exam tip. Keep in mind that a constructive trust will be imposed in the above case even if the will beneficiary did not make the promise until after the will was executed. Furthermore, it does not matter whether the will beneficiary intended to perform the promise when they made it. All that matters is that the testator relied on the promise. CMR chart. Secret trust. Absolute gift in will made in reliance on beneficiary's promise to hold the property in trust for another. Allowed. Constructive trust imposed in favor of intended beneficiary. Semi-secret trust. Gift in will to a person in trust, but does not name trust beneficiary. Not allowed. Trustee holds on resulting trust for testators, legatees, or heirs. Description. Extrinsic evidence result. SECRETVS. Semi-secret testamentary trust. See semi-secret trust. Resulting trust implied. In a semi-secret trust, the will makes a gift in trust but fails to name the beneficiary. The gift fails, and the named trustee holds the property on a resulting trust for the testator's successors in interest. QLTS prep by BARBRI. Trusts. Notes. Enter any notes you'd like to remember here. 18. 3. Transfer of the beneficiary's interest. 3.1 Freely transferable interests presumed. 3.1.1 Voluntary transfers, gifts, and sales. Absent restrictions by statute or by the trust instrument, a beneficiary may freely transfer their interest in the trust. The assigned interest remains subject to all previous conditions and limitations. 3.1.2 Involuntary transfers, creditors. Unless a statute or the trust provides otherwise, the beneficiaries' creditors may reach the beneficiary's interest in the trust. The interest is subject to judicial sale. To avoid this, a court may order the trustee to pay the beneficiary's income to the creditors until the debt is satisfied. 3.2 Discretionary trusts. In a discretionary trust, the trustee is given discretion whether to apply or withhold payments of income or principal, or both, to a beneficiary. 3.2.1 Creditors' rights. Before the trustee exercises their discretion to make payments to the beneficiary's interest is not assignable and cannot be reached by their creditors. Put simply, the beneficiary has nothing to transfer and no interest for creditors to reach. The beneficiary merely has an expectancy to be a beneficiary. Creditors are usually allowed to attach the beneficiary's interest but may not compel the trustee to make a distribution. If the trustee has notice of an attachment by creditors and decides to make payments to the beneficiary, the trustee must make those payments directly to the creditors unless the beneficiary's interest is protected by a spendthrift provision. 3.2.2 Beneficiaries' rights. The beneficiary has no right to payment that they can enforce against the trustee. Thus, the beneficiary cannot interfere with the exercise of the trustee's discretion unless the trustee abuses their power, in which case the court will intervene. 3.3 Restraints on alienation. Spendthrift trusts. A spendthrift trust precludes the beneficiary from voluntarily or involuntarily transferring their interest in the trust, and the beneficiary's creditors are precluded from reaching it to satisfy their claims. The purpose is to protect the beneficiary from their own improvidence. Although a spendthrift trust is a restraint on alienation, most courts uphold spendthrift restrictions. 3.3.1 Characteristics. A beneficiary may not transfer interest. The beneficiary may not transfer their interest. However, once the trustee pays the beneficiary may transfer the property received. B. Creditors cannot attach beneficiary's interest. The beneficiary's creditors cannot reach the beneficiary's trust interest until income or principal has been paid to the beneficiary. Of course, once the trustee pays the beneficiary, the creditors may reach the property. 3.3.2 Restraint on involuntary alienation. Only invalid. A restriction permitting the beneficiary to voluntarily alienate their interest, but purporting to deny creditors the right to reach the beneficiary's interest, is probably invalid. 3.3.3 Attempted assignment in violation of spendthrift provision. A beneficiary's assignees cannot force the trustee to pay them, although the trustee can do so if the beneficiary has not repudiated the trustee's authorization to pay assignees. 3.3.4 Exception. Settlor as beneficiary. In most states, a spendthrift provision is invalid if the settlor is the beneficiary. The settlor cannot protect their own property from their creditors. CMR exam tip. When it is unclear whether a beneficiary is the settlor, determine who furnished the consideration for the creation of the trust. If a person furnishes the consideration, they are the settlor even though the trust is created by another person. 3.3.5 Exceptions for special classes of creditors. Many states allow certain classes of creditors to reach a beneficiary's assets notwithstanding a spendthrift restraint. These include claims of dependents, the government, and persons supplying necessities. For example, a divorced wife can usually reach the husband's interest to satisfy a claim for alimony, and the federal government can reach the interest to pay taxes owing. In a few states, tort creditors can reach the trust assets on the theory that they unlike contract creditors, have no means of protecting themselves against the beneficiary's actions. 3.4 Support trusts. 3.4.1 Use of trust property limited to beneficiary support. A support trust directs the trustee to pay only so much of the income or principal, or both, as is necessary for the beneficiary's support. The interest of the beneficiary cannot be assigned or reached by creditors. 3.4.2 Not assignable. Even without a spendthrift clause, the beneficiary's interest in a support trust is such that no one but the beneficiary can enjoy it. The beneficiary's interest is not assignable by definition. Support trusts are, therefore, impliedly spendthrift. 3.4.3 Standard of support and other resources. If the instrument is silent, the standard of support is the beneficiary's accustomed standard of living. Whether the beneficiary's other income or resources should be taken into account is a question of the settlor's intent and is decided by courts on a case-by-case basis. CMR exam tip. A trust to pay all of the income to aid for his support is not a support trust. When the whole of the income is to be paid to aid for his support, the words "for his support" merely state the motive for the transfer. The beneficiary is not limited to amounts necessary for his support. 4. Modification and termination of the trust. 4.1 By terms of trust. The most common way for a trust to end is by its express terms. A trust will terminate automatically upon the expiration of the term specified in the instrument or when all of the purposes of the trust have been accomplished. Examples: 1. Upon a person's death. 2. When a person reaches a stated age. 3. When a person graduates from college. 4. A stated date. 4.2 By the settlor. Under the UTC and by statute in many non-UTC states, a settlor can revoke or amend a trust unless the terms expressly state that it is irrevocable. However, some states, even some that have adopted the UTC, follow the traditional rule, which provides that a trust is irrevocable unless the settlor expressly reserves the power to revoke or modify the trust. 4.2.1 Revocation of irrevocable trust. Under the law of some states, the settlor may revoke an irrevocable trust upon written consent of all living persons with vested or contingent interests. See below. 4.3 By the beneficiaries. The beneficiaries may agree to modify or terminate the trust if all of the following are true. All beneficiaries agree. Note that the existence of unborn or unascertainable beneficiaries may make this impossible to achieve. All beneficiaries are legally competent. The settlor's intent is not frustrated. The settlor consents or modification or termination will not impair any material trust purpose. Claflin Rule. Examples: the following provisions in a trust are likely to prevent the beneficiaries from modifying or terminating as they are considered material purposes. Support of beneficiary. Spendthrift provision. Payment at certain ages. Payment at certain dates. Discretionary trust. CMR exam tip. Watch for remote and contingent beneficiaries in an exam question on early termination or modification. All beneficiaries must consent, including unborn and uncertain beneficiaries, as well as beneficiaries of future interests, no matter how uncertain or contingent. If any beneficiaries are unborn or uncertain, there must be a party appointed to represent their interests, or they must be virtually represented according to state law. Otherwise, the trust may not be terminated or modified. 4.3.1 Liability of trustee. Where all beneficiaries consent to termination, the trustee is not liable if the trustee accommodates them by distributing the trust assets. 4.3.2 Role of settlor in terminating inter vivos trust. As long as the beneficiaries have a right to terminate, the settlor's objections are not a bar, but may be evidence as to whether termination would defeat trust purposes. However, joinder of the settlor may be deemed a waiver of a material purpose that would otherwise block termination. 4.4 By operation of law. A trust will terminate by operation of law if the property has been exhausted or if the legal and equitable titles have merged. 4.5 By the court. 4.5.1 Early termination. A court may prematurely terminate the trust where the trust's purpose has been completed or has become illegal or impossible. 4.5.2 Doctrine of changed circumstances, equitable deviation. A court may also, upon a change of circumstances unanticipated by the settlor, authorize a deviation from the administrative terms where necessary to achieve the trust purpose. Such changes may not deprive the beneficiaries of their interests in the income or corpus. However, many states allow a deviation that changes beneficial rights, such as invasion of the principal, to achieve the primary purpose of the trust. Under the UTC, a court may modify an administrative or dispositive provision or terminate a trust if, because of changed circumstances, doing so will further the purposes of the trust. 4.6 Duty of trustee upon termination. 4.6.1 Wind up trust business. The trustee's powers do not end immediately upon trust termination. The trustee may continue to exercise powers for a reasonable period of time necessary to wind up the affairs of the trust. 4.6.2 Distribute to remainder beneficiaries. The trustee must then timely distribute trust property to the appropriate remainder beneficiaries. 5. Trust administration. 5.1 Powers of the trustee. 5.1.1 Sources of trustee's power. The trustee can properly exercise only such powers as are expressly or impliedly conferred upon them. A. Express powers. A trustee has those powers expressly conferred by the trust instrument, state law, court decree. B. Implied powers. A trustee has all powers that are necessary or appropriate to carry out the terms of the trust if those powers are not expressly forbidden by the trust instrument. Implied powers include such things as are necessary to operate the trust. Normally, a trustee has no implied power to borrow money, or to mortgage or otherwise encumber trust property. However, such powers are expressly conferred by the UTC. Examples. These implied powers may include the power to sell trust property, how else invest, lease trust property, how else earn income, incur reasonable expenses, how else carry out trust, hire agents, how else carry out trust, mortgage trust property, how else borrow money, repair, how else keep trust property valuable. 5.1.2 Joint powers. Under the traditional view, joint trustees must exercise their power by unanimous agreement. Today, in nearly half the states, any power vested in 3 or more trustees may be exercised by a majority of them. 5.1.3 Imperative, mandatory, powers. A power is imperative, sometimes called a mandatory power, if the trust instrument requires its exercise. If a trustee fails or refuses to perform under an imperative power, a court will, upon petition, order the trustee to exercise the power as required by the trust instrument, provided that exercising the power would not violate the law or be against public policy. Examples. 1. Pay $1,000 each month to beneficiary. 2. Invest in Bell Industries stock. 5.1.4 Discretionary powers. Discretionary powers are ones that the trustee may or may not perform, as the trustee determines in their judgment to be the most appropriate. The trustee must exercise a discretionary power in good faith. A liability for abuse or failure to exercise. Exercise of a discretionary power is subject to judicial review for abuse of discretion. The court will also intervene if a trustee has completely failed to exercise judgment with regard to a discretionary power. B. Grant of absolute discretion subject to court review. Even if the settlor grants the trustee absolute or uncontrolled discretion with regard to some matter, the trustee's acts are still reviewable by the court. Otherwise, There would be no trust because there are no enforceable duties. 5.2 Duties of the trustee. Trustees owe their fiduciary duties to the beneficiaries of the trust. In some states, a trustee of a revocable trust owes duties only to the settlor. 5.2.1 Duty to administer trust. Once the trustee accepts the position of trustee, the trustee is bound to follow the terms of the trust and will be liable for non-compliance. 5.2.2 Duty of loyalty. Absent court approval or express waiver in the trust instrument, a trustee cannot enter into any transaction in which the trustee is dealing with the trust in their individual capacity. A trustee owes a duty of undivided loyalty to the trust and its beneficiaries. A trustee cannot buy or sell trust assets even if the price is a fair one. A trustee may not sell property of one trust to another trust of which they are also trustee. A trustee may not borrow trust funds nor loan their personal funds to the trust, except to protect the trust, and any interest paid on such a loan must be returned to the trust. A trustee cannot use trust assets to secure a personal loan. A trustee cannot personally gain through their position as trustee beyond their trustee fee. A corporate trustee cannot invest in its own stock as a trust investment, but it can retain its own stock if such stock was a part of the original trust residential when the trust was established, provided that retention of the stock meets the prudent investor standard. Self-employment can constitute a form of prohibited dealing. However, if the trustee renders extraordinary services to the trustee may be entitled to additional compensation. CMR exam tip. When faced with a question involving a self-dealing trustee, remember that a trustee's good faith or actual benefit to the trust is irrelevant. Indirect self-dealing. The above self-dealing rules also apply to sales or loans to a trustee's relatives and business associates, and to corporations, of which the trustee is a director, officer, or principal shareholder. Duty to account. The trustee must keep accurate records of all trust transactions, and render accountings to the beneficiaries or the court upon demand. Beneficiaries need this information so they can enforce the trust. Duty extends to all beneficiaries. The duty of loyalty extends equally to all beneficiaries, unless the trust instrument specifies otherwise. Beneficiaries' rights in case of prohibited transaction. If a prohibited transaction takes place, the beneficiary may 1. Set aside the transaction, 2. Recover any profit made by the trustee, or 3. Affirm the transaction. Example. Included in the corpus of the trust are 100 shares of Bell Industries stock. Using the appropriate standard of care, trustee decides to sell the stock so trustee has money to pay for beneficiaries. Medical expenses. Trustee purchases the stock for herself at fair market value. Trustee would not have received more for the stock if she had sold it on the open market. Nonetheless, this transaction is self-dealing and in breach of trust absent contrary language in the trust. If the stock goes up in value, trustee will owe the increase in value to the trust. 5.2.3 General Standard of Care. The trustee must exercise that degree of care, skill, and caution that would be exercised by a reasonably prudent person in managing their own property. And, if the trustee has greater or special skill, they will be held to a higher standard. 5.2.4 Duty to separate and earmark trust property. No commingling. A trustee must keep trust assets physically separate from other assets. Trust property must be titled in the trustee as trustee for a specific trust. This keeps trust property from being confused with the trustee's own property. If the trustee commingles trust assets with their own and some of the property is lost or destroyed, it's presumed that the property lost was the trustee's, and the property still on hand belongs to the trust. Also, if a portion of commingled assets increases in value and a portion of the commingled assets decreases in value, it is presumed that it was the trustee's assets that decreased in value and the trust's assets that increased in value. 5.2.5 Duty to perform personally. Prohibition on delegation of duties. A trustee may only delegate acts that would be unreasonable. To require them to perform personally, the trustee may never delegate the entire administration of a trust or discretionary functions, such as decisions to make discretionary distributions. Investment and management decisions. Traditionally, investment decisions could not be delegated, but under the Uniform Prudent Investor Act, UPIA, a trustee may delegate investment and management functions that a prudent trustee of comparable skills could properly delegate under the circumstances. Remedy. If a trustee improperly limits or surrenders their control, the trustee becomes a guarantor of the fund and is responsible for actual losses, no matter what the cause of the loss. 5.2.6 Duty to defend trust from attack. A trustee owes a duty to defend the trust from legal attack unless examination reveals that the challenge is well-founded. 5.2.7 Duty to preserve trust property and make it productive. The power to invest is normally implied from the duty to make trust property productive. The trustee is expected to take actions to, for example, lease land, collect claims, and invest money. The measure of damages for breach of this duty is the amount of income that would normally accrue from proper investments. 5.3 Investments. In virtually all states, a trustee's investment responsibilities are governed by the Uniform Prudent Investor Act, UPIA. The trust terms can expand or limit the trustee's powers. UPIA provisions apply only if there is no contrary provision in the trust instrument. If the trust instrument provides that investments may be made in the trustee's discretion, it is a question of interpretation whether the trustee's power is expanded beyond the UPIA. Although the investment power may be broadened, such language will be strictly construed. Examples. The following phrases in a trust invoke the prudent investor rule. Note that some of them clearly appear to invoke a much different standard. Prudent person rule. Prudent man rule. Legal investments. 5.3.1 Uniform Prudent Investor Act. A standard of care. A trustee must exercise reasonable care, skill, and caution when investing and managing trust assets. Portfolio approach. Prudence evaluated as to overall investment strategy. Investment decisions must be evaluated in the context of the entire trust portfolio, corpus, and as part of an overall investment strategy that has risk and return objectives reasonably suited to the particular trust. Thus, some speculation may be appropriate or even required. See any type of investment permitted. The UPIA permits a trustee to invest in any kind of property or any type of investment provided the trustee acts prudently. No particular type of investment is inherently imprudent. D. Factors considered in making investment decisions. The following circumstances are relevant and must be considered by the trustee in making investment decisions. General economic conditions. The possible effect of inflation or deflation. The expected tax consequences of investment decisions or strategies. The role that each investment plays within the overall trust portfolio. The expected total return from income and the expected appreciation of capital. Other resources of the beneficiaries. Needs for liquidity, regularity of income, and preservation, or appreciation of capital. An asset's special relationship or value to the purposes of the trust or to one or more of the beneficiaries, for example, a family home or heirloom. Diversification of investments. A trustee must diversify the investments of the trust unless they reasonably determine that the purposes of the trust are better served without diversification. Example. A farmer places the family farm into a testamentary trust for the benefit of his spouse and children. The trustee may decide that because the farmer would have wanted the farm to remain in the family, it is permissible to retain the farm without regard to diversification. CMR exam tip. Watch for a fact pattern containing irrevocable trust and a settlor directing the trustee to make non-diverse investments. Because the trustee of a revocable trust owes their duties only to the settlor in many states, Such a directive may relieve the trustee of their duty to diversify. F. Reviewing compliance with Act. Compliance with the UPIA is determined in light of the facts and circumstances existing at the time of the trustee's decision or action. A trustee who acts in substantial compliance with the Act will not be held liable. G. Trustee with special skills or expertise. Trustees with special skills or expertise, or who have represented themselves as having such knowledge, have a duty to use such skills or expertise. Thus, a professional trustee or attorney may be held to a higher standard. H. Trustee with lower skills. A trustee cannot excuse a breach by proving the trustee possesses and exercises in the trust's private affairs subnormal business judgment. I. Duty to review trust property. When the trustee assumes office, the trustee must review the trust assets to bring them into compliance with the prudent investor rule. If imprudent investments are discovered by a successor trustee, the successor trustee may need to sue the prior trustee for breach of duty. J. Loyalty and impartiality. A trustee must act exclusively for the beneficiary when investing and managing trust assets. Accordingly, social investing may be problematic, especially if the returns from a politically correct investment are lower than from other investments. Social investment refers to the consideration of factors other than the monetary safety of the investments and their potential to earn income and appreciate in value. Examples. Social investing may consider factors such as a company's handling of environmental matters, whether a company does business with countries with policies that do not protect human rights, whether a company employs and pays substandard wages to workers in foreign countries, and the political party affiliation of the company's leadership. K. Impartiality. If there is more than one beneficiary, the trustee must act impartially and not favor one beneficiary over another when investing and managing trust assets. L. Delegation of investment and management functions permitted. A trustee may delegate investment and management functions, but only if a prudent trustee of comparable skills could properly delegate under the circumstances. The trustee must act prudently in selecting an agent, establishing the scope and terms of the delegation, and periodically reviewing the agent's actions. If delegation is proper, the trustee is not liable to the beneficiaries for the decisions or actions of the agent. 5.4 Summary. The fiduciary obligation. Standards imposed on the trustee are harsh and designed to deter wrongful conduct and to ease the burden of proving a breach of duty. Ask yourself, was the act one that the trustee was authorized to perform by the instrument, by state law, or by implication? If the act was proper to perform, did the trustee do so with the appropriate care, skill, and caution? 5.5 Liabilities of trustee. CMR chart definition. Trustee cannot represent both her personal interest and the interest of the trust, i.e., no self-dealing trust assets must be kept physically separate from trustee's personal assets and assets of other trusts, i.e., no commingling. Trustee must personally perform functions that a reasonably prudent person would not delegate. Trustee must use reasonable care to invest the property, prudent investor rule, collect claims due, lease or manage land, record documents, pay taxes, and secure insurance. Examples of breach: buying or selling trust assets for self or another trust, borrowing from or making loans to trust, personal gain through position as trustee, etc. Placing personal and trust funds in same account. Delegation of entire administration of trust, delegating discretionary functions. Failure to diversify in making investments, to obtain reasonable yield on investments, to promptly review investments, to insure property, etc. Remedy: beneficiary may recover any profit from trustee, RM the transaction, or set aside the transaction. Trustee is liable for any resulting loss. Property lost or destroyed is presumed trustees, and any increase in value in commingled property belongs to trust. Trustee is liable for the amount of actual loss to trust. Trustee is liable for losses resulting from breach and for any profit that would have accrued to the trust but for the breach, plus interest. Duties: loyalty, separate and earmarked property. Perform personally, preserve and make trust. Property productive duties of the trustee. QLTS prep by BARBRI. Trusts. 35. 5.5.1 Enforcement by beneficiaries. The beneficiaries may seek to have the trustee surcharged, that is, pay damages suffered by the trust, or removed from office if the trustee breaches their duties. The settlor may sue if they are also a beneficiary, but outsiders cannot enforce the trust. Prior to actual breach, a court of equity will compel the trustee to perform their duties and enjoin the trustee from committing breach. A. Money damages. The trustee is liable to the trust estate for losses resulting from the breach, including depreciation in value of trust property, and for any profit that clearly would have accrued to the trust but for the breach, as well as any profit made by the trustee as a result of their breach. The trustee will also be liable for interest on their liability from the time of the breach. B. Remedies for self-dealing. In the case of self-dealing, the beneficiary may have a choice of the following remedies. Affirm the transaction if the trust profited. Set aside the transaction if the trust lost money. Trace profits from the trustee if the trustee profited. See defenses. Equity will not enforce the trust if the beneficiaries consented to or joined in the breach of trust. The beneficiary must sue within a reasonable time or they will be estopped by the doctrine of laches. Mere failure to object at time of breach, however, does not constitute consent. D. Virtual representation. In any action in which beneficiaries are parties, a minor, incapacitated, or unborn beneficiary may be represented, and bound by any decision, by another beneficiary having a substantially identical interest under the law of many states but only to the extent that there is no conflict of interest. 5.5.2 More than one breach of trust losses cannot be offset. A trustee is not permitted to offset loss from one breach by gain that resulted from another breach. 5.5.3 Removal of trustee. Absent instructions in the trust instrument, the beneficiaries need to go to court to remove a trustee. Basically, a court may remove a trustee if their continuation in office would be detrimental to the trust, taking into consideration both the settlor's intent and the interests of the beneficiaries. There are numerous grounds upon which a trustee may be removed, including the following. Legal or practical incapacity to administer the trust. Unfitness for the position, for example, convicted of a crime or chemically dependent. Commission of a serious breach of trust. Serious conflict of interest. The trustee's insolvency, because a trustee is more likely to embezzle if they are in financial trouble. Extreme friction or hostility between the trustee and beneficiaries but only if it would interfere with proper trust administration. Refusal to post any required bond. Refusal to account. 5.5.4 Trustees' liability for the acts of others. A. Agents. A trustee will be liable for the acts of their agents if the trustee 1. Directs, permits, or acquiesces in the act, conceals the act, or fails to compel the agent to redress their wrong. 2. Improperly selects or improperly delegates, or 3. Fails to exercise reasonable supervision over the agent. B. Co-trustees. A trustee will be liable for acts of a co-trustee if the trustee 1. Approved, acquiesced, or participated in the breach or negligently disregarded their own duties. 2. Concealed the breach or failed to take steps to compel redress. Or 3. Improperly delegated authority to the co-trustee. See predecessor trustees. A trustee will be liable for a predecessor trustee's breach if the trustee 1. Knew or should have known of the breach and failed to compel redress, or 2. Was negligent in determining what property should have been delivered to them. D. Successor trustees. Successor trustees can maintain the same actions as the original trustee. 5.5.5 Effect of exculpatory clauses. Clauses attempting to relieve a trustee of liability for breach of trust generally are strictly construed, but are enforceable where 1. No bad faith, intentional breach, or recklessness is involved, or 2. They were not inserted in the trust as a result of the trustee's abuse of a confidential relationship with the settlor. Clauses absolving the trustee from all liability, however, are void. 5.5.6 Trustees' liability to third parties. A contract liability. Unless the contract specifically provides otherwise, a trustee is personally liable to third parties on contracts made in the course of trust administration. A trustee is entitled to reimbursement, indemnification, from the trust, however, if the contract was within their powers and the trustee acted with reasonable prudence. B. Tort liability. A trustee is personally liable for torts committed in the course of the trust administration, including those committed by the trustee's agents. There is indemnification only if the trustee was not personally at fault and the tort occurred as a normal incident to activity in which the trustee was properly engaged. If the trustee is entitled to indemnification, creditors to whom the trustee is liable can reach trust assets to satisfy claims. Note that under the UTC, a trustee is liable only if they are personally at fault. The doctrine of respondeat superior does not apply. 5.6 Liability of third parties to the trust. 5.6.1 Property improperly transferred to non-bona fide purchaser. A beneficiary or successor trustee can set aside transactions that are breaches of trust if the property is not in the hands of a bona fide purchaser, BFP. 5.6.2 Transfer to BFP cuts off beneficiaries' interests. A BFP cuts off the beneficiary's equitable interests. A third party is a BFP if the party acquires the property for value and without notice of the trust. A person who knows of facts requiring an inquiry, which if pursued would have revealed the existence of a trust, is not a BFP. An innocent donee of trust property is not liable for damages but must restore the property, its value, or its substitute to the trust. 5.6.3 Participation in breach of trust. A knowing participant in a breach of trust is liable for the resulting loss to the trust estate. 5.6.4 Direct suit by beneficiaries. Direct suits by beneficiaries are not permitted against third parties who damage trust property. The trustee alone can sue. The beneficiary's remedy is to bring suit in equity to compel the trustee to sue the third party. A. Exceptions. Direct actions by beneficiaries against third parties are permitted where the trustee 1. Participated in the breach, 2. Has left the jurisdiction and no successor trustee is appointed, or 3. Fails to sue a third person liable in tort or contract. 5.7 Allocation of receipts and expenses between income and principal accounts. 5.7.1 Uniform Principal and Income Act. A majority of states have enacted the Uniform Principal and Income Act, UPIA. This act, which applies to all trusts and estates unless the governing instrument provides otherwise, gives the trustee or personal representative an adjustment power to reallocate investment portfolio return. This adjustment power authorizes the trustee to characterize items such as capital gains, stock dividends, etc., as income if the trustee deems it appropriate or necessary to carry out the trust purposes. A duty of fairness to all beneficiaries. The trustee is under a duty to administer the trust impartially, except to the extent that the trust or the will manifests an intent that one or more of the beneficiaries is to be favored over the others. B. Adjustment power. If the trust calls for distribution of trust income to a beneficiary, the trustee must follow traditional trust accounting rules by distributing interest and dividend income, etc., to the beneficiary. If the resulting distribution effectuates the settlor's intent and the purposes of the trust, then nothing further needs to be done. If, however, the trustee determines that by distributing only the trust's income the trustee is unable to comply with the requirement that all beneficiaries be treated fairly, the trustee may adjust between principal and income to the extent necessary. See factors to be considered. In deciding whether and to what extent to exercise the adjustment power, the trustee must consider the following factors. 1. The nature, purpose, and expected duration of the trust. 2. The intent of the settlor. 3. The identity and circumstances of the beneficiaries. 4. The need for liquidity, regularity of income, and preservation and appreciation of capital. 5. The nature of the trust's assets. 6. The net amount allocated to income under the other sections of the Act and the increase or decrease in the value of the principal assets. 7. Whether and to what extent the trust gives or denies the trustee the power to invade principal or accumulate income. 8. The actual and anticipated effect of economic conditions on principal and income and effects of inflation and deflation. And 9. The anticipated tax consequences of an adjustment. D. Adjustment not permitted if result would be adverse tax consequences. The trustee may not make an adjustment if the trustee is a beneficiary of the trust, as this would give the beneficiary a general power of appointment for estate tax purposes, and the trust assets would be taxed in the beneficiary's estate. Also, an adjustment cannot be made if the adjustment power would disqualify the trust for a federal estate tax marital or charitable deduction. 5.7.2 Allocation of receipts. In general, the allocation rules follow traditional accounting rules. For example, net rental income is income and the proceeds of sale of a trust asset are principal. A. Receipts from entity. Money received from an entity such as a corporation, for example, cash dividends, is characterized as income unless the money is characterized as a capital gain for federal income tax purposes, or is received in partial or total liquidation of the entity. All property other than money received from an entity, for example, stock dividends, is characterized as principal. B. Insurance policies and other contracts. Proceeds from a life insurance policy or other contract in which the trust or trustee is named beneficiary are allocated to principal. If a contract insures the trustee against a type of loss, the proceeds are allocated to income. Dividends on an insurance policy are allocated to the account from which the premiums are paid. See Deferred Compensation 10% Default Rule. For periodic receipts from a deferred compensation plan, for example, a pension plan, the receipt is income to the extent that the payment is characterized by the payer as income, and the balance is principal. If no part of the payment is characterized as income or as a dividend, 10% of the payment is characterized as income and the balance is principal. Deliquidating assets such as patents, copyrights 10% rule. A liquidating asset is an asset whose value will diminish over time because the asset is expected to produce receipts over a limited period. Proceeds from such liquidating assets, for example, patents, copyrights, are allocated 10% to income and 90% to principal. Mineral interests 10% rule. For most oil, gas, mineral lease, and water right payments, receipts are allocated 10% to income and 90% to principal. F. Unproductive property. Under the former law, if a particular trust asset produced little or no income, on the asset sale, the income beneficiary was entitled to a portion of the sale proceeds under the principle of delayed income. Because the UPIA looks to the total return from the overall portfolio, the unproductive property rule was repealed except for certain trusts that are intended to qualify for the estate tax marital deduction. 5.7.3 Allocation of expenses. A. Expenses charged to income. The following expenses are charged against income: 1/2 of the regular compensation of the trustee and of any person providing investment advisory or custodial services to the trustee, 1/2 of all expenses for accountings, judicial proceedings, and other matters affecting both income and remainder interests, the entire cost of ordinary expenses, and insurance premiums covering the loss of a principal asset. B. Expenses charged to principal. The following expenses are charged against principal: the remaining 1/2 of the compensation of the trustee and any person providing investment advisory or custodial services to the trustee, the remaining 1/2 of all expenses for accountings, judicial proceedings, and other matters affecting both income and remainder interests, payments on the principal of a trust debt, expenses of a proceeding that concerns primarily an interest in principal, estate taxes, and disbursements related to environmental matters. CMR chart income receipts, ordinary receipts from use or investment of trust property, example rents, interest, cash dividends, proceeds from contract insuring trustee against loss, 10% of payment from a deferred compensation plan, example pension plan, unless otherwise characterized, 10% of proceeds received from a liquidating asset, example patents, copyrights, 10% of proceeds received from a working interest, example oil and gas interests, expenses, 50% of regular compensation of the trustee and any person. Providing investment services, 50% of all expenses for accountings, judicial proceedings, and other matters affecting income and remainder interests, ordinary expenses, insurance premiums covering loss of a principal asset, principal receipts, extraordinary receipts, example proceeds from sale of trust assets, stock dividends, proceeds from life insurance policy naming trust or trustee as beneficiary, 90% of payment from a deferred compensation plan, example pension plan, unless otherwise characterized, 90% of proceeds received from a liquidating asset, example patents, copyrights, 90% of proceeds received from a working interest, example oil and gas interests, expenses, 50% of regular compensation of the trustee and any person. Providing investment services, 50% of all expenses for accountings, judicial proceedings, and other matters affecting income and remainder interests, expenses of a proceeding that concerns a principal, interest payments on the principal of a trust, debt, estate taxes, disbursements related to environmental matters, allocating receipts and expenses under the UPA. QLTS prep by BARBRI. Trusts. 43. 6. Charitable and honorary trusts. 6.1 Distinctive rules apply to charitable trusts. The rules are basically the same for private and charitable trusts, but the rules governing charitable trusts differ from those applicable to private trusts in 3 important ways. A charitable trust must have indefinite beneficiaries, it may be perpetual, and the Cypress doctrine applies. 6.2 Trust must be for charitable purposes. A charitable trust must have a purpose considered to benefit the public. Charitable purposes include the relief of poverty, the advancement of education, science, or art, the advancement of religion, the promotion of health, the accomplishment of government purposes, such as parks, museums, and playgrounds. 6.2.1 No special language necessary as long as intent clear. The charitable purpose may be expressed in very general terms. A charitable trust will be implied when the settlor's charitable purpose is clear. 6.2.2 Trust must be significantly altruistic in supplying benefits. The class to be benefited may be limited, but may not be so narrow as to only benefit a few individuals whom the settlor wishes to aid personally. For example, a settlor cannot limit benefits to their family members. However, just because some family members might be benefited, for example, a trust to provide parks in the city where the family lives, does not keep the trust from being charitable. 6.3 Beneficiaries must be indefinite. Beneficiaries of a charitable trust must be indefinite. In other words, a charitable trust must benefit the public generally or an indefinite class of members of the public. CMR exam tip. Keep in mind that this rule does not mean that the beneficiary cannot be a specific charitable entity, such as the American Red Cross or the Humane Society. The ultimate beneficiaries, the individuals the specified charity serves, are indefinite, even though the entity is specific. 6.4 Cypress. What happens when the trustee cannot carry out the trust as written? When a charitable purpose selected by the settlor is accomplished or becomes impracticable, the court may select an alternative under the doctrine of Cypress, which means as near as possible. The court must find a general charitable intent on the part of the settlor and ascertain their primary purpose. This doctrine applies to outright charitable gifts as well as to charitable trusts. 6.4.1 Settlor's general charitable intent. To apply Cypress, the court must determine that the settlor had a general charitable intent, that is, the the settlor did not intend to limit their gift to a particular charity regardless of the circumstances. If a specific intent alone is found, the trust fails and passes as a resulting trust to the settlor successors in title. Note that under the UTC, general charitable intent is presumed. Example: in 1940, testator executed a will leaving money for the development of a polio vaccine. Testator has now died and a polio vaccine already exists. The court may apply cypres to save the gift for purposes which are similar. Appropriate alternatives may include the distribution of polio vaccines in foreign countries or to fund research for finding a cure for other crippling childhood diseases such as muscular dystrophy or cerebral palsy. The court may examine extrinsic evidence in its quest to ascertain what substitute charity or purpose most closely comports with testator's intent, albeit not expressed in the will. 6.5 Rule against perpetuities. Charitable trusts are not bound by the rule against perpetuities and thus may be perpetual. Also, the rule against perpetuities does not apply to the shifting of the beneficial interest in a trust from one charity to another on the happening of a condition. The rule does apply, however, to shifts between private and charitable uses. 6.6 Enforcing charitable trusts. In many states, the settlor and potential beneficiaries have no standing to enforce the terms of a charitable trust. The duty of enforcement is placed upon the state attorney general. Under the UTC, however, the settlor and qualified beneficiaries, that is, current beneficiaries and first-line remaindermen, have standing to enforce the trust. 6.7 Honorary trusts or purpose trusts. An honorary or purpose trust is a trust that is not for a charitable purpose and has no private beneficiaries. Honorary trusts are commonly established for the benefit of pets or for the maintenance of burial places. Because there is no human beneficiary to enforce an honorary trust, the trustee is on their honor to carry out its terms. Courts uphold honorary trusts as long as the named trustee is willing to perform their duties. Failing this, a resulting trust is imposed. Absent special statutes, many jurisdictions will void an honorary trust on the basis of the rule against perpetuities if its duration may be more than a human life in being plus 21 years. Under the UTC, honorary trusts are enforceable up to 21 years by someone named in the trust instrument or appointed by the court. The UTC also recognizes trusts for the care of an animal alive during the settlor's lifetime, which terminate when the animal dies. 6.7.1 Constructional outs. To avoid the perpetuities problem, some courts use constructional outs to save the gift, such as by holding that 1. The trust is personal to the named trustee, and or 2. Because the fund will be exhausted within the perpetuities period, it cannot last beyond the period and does not violate the rule. 7. Trusts arising as a matter of law resulting and constructive trusts. 7.1 In general, resulting and constructive trusts are implied by law or imposed by courts. Resulting trusts involve reversionary interests and are based on the presumed intent of the settlor. Constructive trusts are used to prevent unjust enrichment. They arise either where there is no valid express declaration of trust or, frequently, when no trust was even intended. The statute of frauds is inapplicable. 7.2 Resulting trusts. 7.2.1 In general, resulting trusts arise by implication from the settlor's conduct. Resulting trusts are of three types. 1. Purchase money resulting trusts. 2. Resulting trusts arising on failure of an express trust. And 3. Resulting trusts arising from an incomplete disposition of trust assets, that is, excess corpus. A. Beneficiaries of resulting trust. The settlor is the beneficiary of a resulting trust. If the settlor is deceased, the settlor's successors in interest, heirs or beneficiaries under the settlor's will, are the beneficiaries. B. Purpose. The purpose of a resulting trust is to do what the settlor would have done had the settlor put their intent into words. 7.2.2 Resulting trust on failure of express trust. A circumstances giving rise to resulting trust. A resulting trust arises where a settlor has conveyed property to a trustee under an express trust and 1. The trust is void or unenforceable, or 2. The beneficiary is dead or cannot be located. A resulting trust may also apply on failure of a charitable trust where cypres is inapplicable. In such event, the express trust terminates and the settlor becomes the beneficiary of the resulting trust. Example: Susan signed a trust instrument which indicated the beneficiaries of the trust would be her friends as selected by trustee. Susan then conveyed several items of property to trustee. The court declared the trust invalid because Susan did not name ascertainable beneficiaries. Assuming the instrument is silent, trustee holds the property as the trustee of a resulting trust in favor of Susan. Susan's attempt to convey beneficial title to the property failed and thus she is deemed to have retained that title. B. Circumstances where resulting trust not implied. A resulting trust will not be implied where 1. The trust instrument specifically or implicitly provides for disposition of trust property when the trust has failed or been completed. 2. The settlor was given consideration for their original transfer in trust. 3. The settlor created the trust for an illegal purpose. Or 4. Cypres is applicable in cases of charitable trusts. 7.2.3 Resulting trust implied from excess corpus. A resulting trust in favor of the settlor also arises when the trust purpose is fully satisfied and some trust property remains. There could be a resulting trust, a part of the corpus even before the trust is terminated if it is clear that there is excess trust corpus. Example: Settlor created a valid trust which had the following dispositive provision: trustee shall pay all income from the trust property to Bruce so long as Bruce is alive. Bruce has died. Because settlor failed to name a remainder beneficiary, the court will find a resulting trust in favor of settlor or, if settlor has already died, settlor successors in interest. 7.2.4 Purchase money resulting trusts. A purchase money resulting trust is presumed whenever X, the beneficiary, furnishes the consideration, usually money, but any other valuable consideration suffices, for the acquisition of real or personal property but, with X's consent, title is taken in the name of Y, the trustee. Seller legal title recipient of legal title, Y, supplier of purchase money, X. In this type of situation, there are three possible explanations for the relationship between the parties. Settlor/beneficiary of PMRT, trustee of PMRT. Donor-donee. Creditor-debtor. A form of consideration immaterial. The consideration paid by X must be for purchase of the property. Sums paid by X to make improvements on the property or to pay taxes on it do not give rise to a trust. B. Time when consideration furnished. The consideration, or obligation to pay, must be supplied at or before the time Y takes title. C. Burden of proof on one claiming as beneficiary. The burden is on X, the party claiming to be the beneficiary of a resulting trust, to prove by clear and convincing evidence that they supplied the consideration. D. Rebuttable presumption of resulting trust. Once X proves that they supplied the consideration, a resulting trust is presumed, but Y can rebut by showing that no trust was intended. For example, payment was a gift or loan to Y or satisfaction of a debt owing to Y. Recitals as to who paid consideration are not conclusive. See loan if transferor expects to be repaid. If X, the person providing the consideration, expects to be reimbursed, the relationship is a loan rather than a purchase money resulting trust. In a purchase money resulting trust, X expects to receive an interest in the property, not the consideration back. The exceptions. See no trust presumption where parties closely related. Where there is a close personal relationship between the parties, for example, X, the party paying consideration, is the parent, grandparent, or spouse of Y, a gift is presumed rather than a trust. This presumption is also rebuttable. The normal presumption of a trust applies where the person furnishing consideration is the uncle, aunt, brother, sister, child, or grandchild of the person receiving title. See unlawful purpose. If X and Y take title for an illegal purpose, a trust cannot be implied, although modern cases suggest that the implied trust is still proper where X's misconduct is slight compared to the unjust enrichment Y will enjoy if permitted to keep the property. See transferee obtained title wrongfully. No resulting trust arises when the transferee obtained title wrongfully, for example, by fraud, although a constructive trust may be imposed. F. Pro rata resulting trusts. Where X supplies only part of the consideration, the resulting trust in their favor is only for a pro rata portion of the property. 7.3 Constructive Trusts. 7.3.1 Basic Principles. A constructive trust is not really a trust but rather is a flexible equitable remedy to prevent unjust enrichment resulting from wrongful conduct, such as fraud, undue influence, or breach of a fiduciary duty. Equity turns the holder of legal title into a trustee when they may not in good conscience retain the beneficial interest in the property. The constructive trustees' only duty is to convey the property to the person who would have owned it but for the wrongful conduct. A must be requested. A constructive trust must be requested as a remedy in a court action. A constructive trust is not automatic, it must be pled and proved. Proof of the facts necessary to establish a constructive trust must be made by clear and convincing evidence rather than a preponderance of the evidence in some states. B. Requires particular property. For a constructive trust remedy, the plaintiff must be able to identify particular property as the trust rests. The mere proof that a defendant has been guilty of wrongdoing against the plaintiff and that the defendant has assets that could be used to satisfy the plaintiff's claim is not a sufficient basis for imposing a constructive trust. 7.3.2 Constructive trust arising from theft or conversion. If Y steals property from X, title remains in X, there is no need to imply a trust. But if Y uses the property to acquire other items, Y takes title to the items and holds them in constructive trust for X. 7.3.3 Constructive trust arising from fraud, duress, etc. Where Y acquires property from X by fraud, duress, mistake of fact, or by breach of a fiduciary duty owed to X, Y holds the property in constructive trust for X's benefit. If property is conveyed to a third party who is not a BFP, the third party can be declared a constructive trustee. If Y takes property under a forged or fraudulent will, Y holds it in constructive trust for its rightful inheritor. This is true even if Y is innocent. Example: on Halloween night, Carrie wanted to execute her will, leaving all her property to Claytonia, a non-family member. Several of Carrie's family members were in the room and noticed that the will disinherited them. They then used physical force to prevent Carrie from signing her will. Carrie tried to sign the will, but unlike Stephen King's Carrie, this Carrie was weak. She struggled so hard that she suffered a severe hemorrhage and lapsed into a coma from which she never recovered. Accordingly, Carrie died in state and her entire estate passed to her heirs. The court may impose a constructive trust on the property that the heirs inherited from Carrie for the benefit of Claytonia. The heirs' inappropriate actions prevent them from enjoying the fruit of Carrie's estate death. The fact that the property eventually goes to a person named in a document which was not executed with the formalities of a will does not matter because the constructive trust is imposed on the property after it passes to the heirs under estate succession. The court can ascertain the ultimate recipients of the title to property by referring to documents which cannot stand on their own because they would violate the statute of frauds or statute of wills. Some courts will even impose a constructive trust remedy on Carrie's innocent heirs who were not involved with the dastardly conduct. The innocent heirs would not have received any property but for the acts of the evil heirs, and thus the court may use its equitable power to do complete justice and impose the constructive trust on both evil and innocent heirs alike. 7.3.4 Constructive trust arising from breach of fiduciary duty. The fiduciary's duty forbids them from taking title to property belonging to a beneficiary and from seizing for themselves an opportunity to acquire property that comes to them in their capacity as fiduciary. If the fiduciary violates this duty, courts may impose a constructive trust in favor of the person to whom they owe the duty. 7.3.5 Constructive trust arising from homicide. In states without a slayer statute, if Y kills X and is convicted of murder or manslaughter, Y holds any property acquired from X by will or inte Stacy as constructive trustee in favor of whomever would have taken the property had Y predeceased X. A. Where victim and killer held property in joint tenancy. Where X and Y were joint tenants, the killer Y may be trustee of only a 1/2 interest and own the balance free of trust. Or Y may hold the whole interest in constructive trust less Y's life estate in 1/2, depending on the jurisdiction. 7.3.6 Constructive trust arising from breach of promise. A general rule: no constructive trust. The general rule is that a mere breach of a promise will not raise a constructive trust. Thus, where A transfers real property to B on B's oral promise to hold it for C, some jurisdictions consider the statute of frauds a bar. But the trend is to impose a constructive trust for C. B. Exceptions to general rule. A constructive trust will be imposed in the following cases: fraudulent promise, promisor never intended to keep it. Breach of promise by one in a confidential relationship, which can include attorney-client, doctor-patient, business partners, family relations, and friendships. Example: George and Leo had been good friends for 20 years. Leo decided to open a new business and convinced George to transfer some of his property to the business. Although Leo's conduct did not amount to fraud, he knew that the business was risky and that George would have difficulty regaining his property. George could easily have discovered these facts if he had done even a cursory investigation, but due to their long friendship, George did not believe that it was necessary. George has a good chance of securing a constructive trust remedy to recover the property. Although Leo's conduct did not amount to fraud, he abused a long-standing friendship relationship. Breach of promise by the decedent's devisee or heir to hold property for the benefit of a third person. Example: testator executed a will containing the following dispositive provision: I leave my home to beneficiary. After testator died, Victor claims that testator and beneficiary had an oral agree meant that beneficiary would hold the home in trust for Victor's benefit. This example demonstrates a secret trust, that is, a will which purports to make an absolute gift but where there is actually an agreement between the beneficiary and the testator that the beneficiary will hold the property in trust for a person the testator had separately indicated. If beneficiary retained the property, beneficiary would be unjustly enriched because testator would not have made the devise but for beneficiary's agreement to hold the property in trust for Victor. Even though the will does not contain the terms of the trust, the court may impose a constructive trust on the property for Victor's benefit. Breach of promise by the decedent to devise property to one rendering services in reliance thereon, but no constructive trust here if damage is adequate. Breach of promise to the debtor by the buyer at the foreclosure sale to hold the property for the debtor, causing the debtor to forego bidding at the sale, but in many jurisdictions, no constructive trust if damage is adequate. See standard of proof. The burden of proof is on the party seeking the constructive trust to establish facts relied upon by clear and convincing evidence rather than a preponderance of the evidence in some states. 7.4 Obligations of trustee of constructive or resulting trust. Constructive and resulting trusts are passive trusts. Once the court has declared such a trust to exist, the trustee's sole duty is to convey legal title to the beneficiary. The trustee must also account for profits taken from the property or fair rental value of the trustee's use of it from the time of the occurrences raising the implied trust. There is no duty on the trustee to invest trust property. 7.5 Application of equitable principles. Actions to impress constructive or resulting trusts are in equity, and most equitable principles are fully applicable. For example, the unclean hands doctrine, and the rule that one seeking equity must do equity, such as requiring the beneficiary to reimburse the trustee for sums expended in good faith to improve the property, pay taxes on it, etc. However, the rule that an adequate remedy at law bars equitable relief is not applicable except to the breach of an oral promise to make a will, or to hold property purchased at a foreclosure sale for the benefit of the promisee. 8 Will substitutes. 8.1 In general, if a person wants to transfer property at the moment of death, they must comply with formal requirements for making a will. However, a settlor may make certain inter vivos, lifetime, transfers without the formalities of a will. 8.2 Inter vivos trusts. The test for distinguishing a trust from a will is whether the transfer creates some present gift, even if that gift is of a future interest subject to divestment. That is, revocable trust is valid because interest passes to the beneficiary during the settlor's lifetime, it merely becomes possessory on the settlor's death. 8.2.1 Determining whether an interest passes. A settlor may retain powers over trust property. The tendency is to uphold trusts even where the settlor has retained great rights and powers over the trust property. If the settlor retains a life estate and the power to revoke, the trust is generally upheld. B. Where settlor is trustee. Even if the settlor is the trustee, as well as the life tenant with power to revoke, most courts uphold the trust where the settlor notified third parties or took some action that made their intention to establish a trust clear. 8.2.2 Advantages of revocable trust. A revocable trust may be used for convenient management of assets, to plan for the possibility of incapacity, to avoid probate costs and delays, to permit secrecy as to beneficiaries and assets, and to allow the settlor to choose the applicable state law. In some states, a revocable trust can be used to undercut a surviving spouse's elective share by removing the assets from the probate estate. Under the UPC and in most states, however, lifetime transfers are subject to the elective share if the grantor spouse retained the power to revoke, or to invade, consume, or dispose of the principal. 8.2.3 Pour over gift from will to revocable trust. Under the Uniform Testamentary Additions to Trusts Act, a settlor can make gifts by will to a trust, even an amendable and revocable trust established during their lifetime. The trust may remain unfunded during the settlor's lifetime. The trust must be clearly identified from language in the will. 8.3 Life insurance trusts. Despite the absence of a significant residential beyond the contract right to receive proceeds when the insured dies, prior to the settlor's death, inter vivos life insurance trusts are upheld. 8.4 Totten Trust Bank Accounts. In a Totten Trust, a bank account depositor declares themselves trustee of the account for a person who is to receive the money in the account at the time of the depositor's death.
You know what? I got to go back to studying. It's more than an hour and 43 minutes of tort study that I need to study for the second time. So I can memorize it all right? So I'll let you go. Bye, Mom.
A Totten trust is revocable by 1. The withdrawal of funds, and 2. Any lifetime act manifesting the intent to revoke, typically by following the terms of the account contract. It does not protect funds in the account from creditors' claims, and it terminates if the beneficiary predeceases the depositor. 8.5 Uniform Transfers to Minors Act. The Uniform Transfers to Minors Act, UTMA, provides a convenient procedure for making gifts to minors who have no legal capacity to manage or sell property, under which property may be transferred to a person as custodian for a minor.
Okay, so find these tights that you're going to accuse me of stealing, please.
No.
Yeah,
get out.
I'm going to get them.
No.
Yeah, I'm serious. I'm going to get them.
If you don't soon get out, I'm calling security on you.
Call them.
Statutory power. The custodian is a fiduciary subject to the standard of care of a prudent person dealing with property
the
of
whole
another.
point is, you don't give a shit. I thought I was going to go to church early with you to get more time accomplished so we can get stuff done today. But I wake up.
Get out of my apartment.
I wake up and you're in the middle of recording, and I'm supposed to stay awake for an hour till after staying up till 2 o'clock.
Out of my apartment.
And this is what hurts, is that you don't care. This is the reason why I bring it up, and I'm pissy about it.
Get
You
out of my apartment.
You act like you don't care.
Get out of my apartment for your own safety.
I am leaving.
Get out. Okay, when you
You're not
don't,
proving a point.
be
I'm
quiet.
leaving. You're not proving a point.
The mere abstract
Point is, you
fear
could
of death
care
from a
less.
future cause. For
I'm
example,
trying to like
fear of flying, fear of death in
show
war,
you that it hurts. Like, you
etc.
don't fucking
is
think
not
about
sufficient.
anything else.
8.6.1 Delivery and
Try again another
acceptance.
time.
I thought I would do
Gifts
us a favor
causam
by trying
ordis
to
are
get up early,
subject to the
and then
same
I'm staying
delivery
up all
and
night,
acceptance requirements as inter
waiting for you
vivos
to come to
gifts.
bed, and then
Delivery
up all
may
night
be
with
accomplished by
fireworks.
actual delivery. That
Up
is,
early for no
the donee
reason.
received dominion and control over the subject matter of the gift, or constructive delivery of an item that would be impossible or impracticable to manually deliver. That is, the donor surrenders the means to obtain possession and control, such as keys. Symbolic delivery, which is most commonly effectuated by delivering a written instrument that evidences ownership, is not sufficient to accomplish a gift causam ordis in many states. 8.6.2 Revocation. A gift causam ordis is revocable, and is revoked in the following manner. By an affirmative act indicating an intent to revoke ownership in the donor. By operation of law if the donor recovers from the condition that put the donor in fear of impending death. By operation of law if the donee predeceases the donor. CMR exam tip. Remember, a gift causam ordis is valid as long as the donor fails to recover, even if the donor dies of a different cause. 8.6.3 Creditor claims. A gift causam ordis is subject to the claims of creditors of the donor's estate. Warning, empty page.
There's some guy stealing, some other guy who's not Steve. And obviously he wouldn't sleep with that fucking retard, so it's obviously someone else. Unless you really think that fucking little so it's clearly someone else. Someone else stole your shit.